Lawyers, what's the worst case of you should have mentioned this sooner you've experienced? Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to S, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial in passing she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as freak, unethical, and common practice for that prosecutor office. I get the interview and all of 4 minutes and she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense I had. We had a come to Jesus talk the next day and she took her offer, which was the minimum of 5 years to serve. Had a guy with a DUI. Asked about any criminal history. He said no. So I started the paperwork for ARD for him. It's the first time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the DA, find out the guy had another DUI a year prior. Also was on probation from the first one still. His excuse for not telling me was the first DUI was made up and he wasn't intoxicated, but pled guilty anyway. Unfortunately I ended up representing him for both bases. Did not get paid nearly enough for the shit I went through, but I did manage to keep him out of jail so he could take care of his elderly mother. Made him give up his vehicles though. As a solicitor, one of the most annoying things I've had happen was, after an hour-long consultation with an older couple about changing the husband's will, the wife hands me a letter from his doctor, which says the husband has dementia and does not have capacity to sign medical documents. Like, you didn't think that was a good place to start? One more for you. My first ever hearing in front of a judge as an attorney was a Social Security disability appeal. My client had been crushed at work a few years ago, and his entire left side of his body was mangled. He had PTSD from seeing his dad shoot himself as a kid, loads of mental health issues and physical ones as well. Just my luck, I get the biggest dickhead judge the SSA has to offer. It's sort of an unspoken rule that you don't interrupt someone's opening statement. You don't make objections. You don't interrupt. Well, I get 3 sentences into my opening, and I was listing his conditions, and the judge screams over me, "You forgot one. What about the drug abuse disorder? When was the last time your client did heroin?" I froze for a half a second, glared at said client, and said, "Well, Your Honor, I didn't mention." That's similar to how I didn't mention his prediabetes and seasonal allergies. It isn't relevant to his ability to work as he hasn't abused drugs in several years. Additionally, he admitted that he used drugs to cope with his mental health disorders, which he has taken much better control over since he began counseling. I was damn proud of that response. My client won the case. I called to tell him. His GF answered and informed me he was in jail for the next 36 months for stealing a car. A person involved in a motorcycle accident who sustained legitimate but not serious injuries. CCTV showed the incident. They were very much not at fault. They decided this was their big payday, claimed they could barely walk, had PTSD, serious back trouble, would never work again. The whole 9 yards. They neglected to tell their lawyer they had been working a manual labor job, riding motorcycles again, did a bungee jump. All of which we caught on video / they documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued for fraud. It was a fun phone call after we sent the tape full of evidence. I was on the other side, but I saw the other lawyer seemed to have one of these moments. So the plaintiff sued, saying the insurance company had improperly denied her claim for homeowners insurance after her claim for property damage had been denied. I don't know what she told her lawyer, but as the examination under oath, like a deposition, proceeded and I laid out more of the details, I think the other lawyer understood. So basically, if a pipe bursts in your house and causes water damage, that's probably going to be covered. There's generally an exclusion that says you don't get coverage if the pipe burst because you didn't take reasonable care to keep it from freezing. This person left her upper Midwest home at the end of the summer and didn't come back until like March. Didn't winterize the house, didn't shut off the water, didn't make sure the heat was on, except for a tiny heater on the second floor, and didn't even have anyone checking on the house. Well, pipes froze and burst all over the house. The water utility calls her and says there's a lot of water going through your meter. You might have a leak. She calls someone to go check on the house, but they can't get in because the freaking door is frozen shut. Freak it. They abandoned further efforts to check on the house. The water utility sent someone out and they figured out that many hundreds of thousands of gallons had gone through the meter and they cut the water off at the main line. She doesn't come back until spring. Over time, there was freezing and thawing. Then when it warmed up, the place molded through and through. Everything in the house was completely freaked. If I had to guess, she left out a lot of those details when she described the case to her lawyer. Co-suspect was defended by another lawyer who argued in his closing arguments that there should have been a police lanoop during the investigation since the suspects were brought into the station when the victim was still there. Client turns to me and says that there had been a lanoop and they were not identified. This lanoop was about 30 minutes after the alleged robbery. Nothing in the file suggests a negative police lineup. We do trials based on written statements by police. They are hardly ever in court to testify. I mention what my client said in my closing arguments. The prosecutor's mouth drops and she becomes pale. Hearing is suspended for further investigations. Couple of weeks later, police officers are testifying in shame that they forgot to finish the report on the police lineup. Prosecutor's case is thrown out for irreparable harm to the trial. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily meth user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rockstar mom to a kid with special needs. Unlike 90% of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning meth user I've met. But freak, that hearing would have gone quite differently had she mentioned that to me beforehand. FYI, most of the time we can deal with bad facts. At the very least, we can give you the advice you need to hear. But there isn't much I can do with surprise facts in the middle of a trial. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller, and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower level grunt and explained that I needed a call back in an hour from a person who can clarify the situation or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets.